My name is Beth Ann Childs, and I am an attorney that focuses my practice on representation of municipal bodies. Today, I'm going to be talking about Planning Commission training. It's geared towards the City of Stillwater, but it's equally applicable for other planning commissions in other jurisdictions. Origin of the Planning Commission. The idea of the Planning Commission originated in the Standard Planning and Zoning Enabling Acts, developed under Herbert Hoover in the 1920s. These model ordinances were drafted in order to standardize land use planning procedures across the U.S. Almost all states adopted the Standard Acts, which authorized cities, towns, and counties to establish planning commissions and adopt zoning and subdivision regulations. These acts defined and established the essential duties of planning commissions, boards of zoning appeals or adjustment, and legislative bodies as they address planning and development issues. Some of the key roles of the Planning Commission include making recommendations to the legislative body on community development issues, including the zoning ordinances and zoning map amendments, preliminary and final subdivision plats, special permits, land use plans, and capital improvement plans. Other roles include participating in the process of updating the comprehensive plan, providing an opportunity for long-term, in-depth study of major issues, providing an opportunity to promote intergovernmental cooperation with school districts, utilities, and neighboring jurisdictions, and all duties as set forth in 11 OS Section 45-101 through 45-106. I would first like to talk a little bit about some of the basic legal principles that have been addressed by the Oklahoma Supreme Court. The Oklahoma Supreme Court has consistently held that unless a zoning decision of a municipality is found not to have a substantial relation to the public health, safety, morals, or general welfare, or to constitute an unreasonable, arbitrary exercise of its police power, its judgments will not be overturned by the district court. Importantly, courts may not substitute their judgment for that of the municipal legislative body, and the court's duty is to determine whether the restriction on the use of the property is a reasonable exercise of power under the zoning statute. When the validity of a legislative classification for zoning purposes is fairly debatable, the legislative judgments must be allowed to stand. It is well settled that the action of the municipality in enacting, amending, or refusing to amend a zoning ordinance is a legislative function. When the validity of a municipal zoning ordinance is challenged, it is the duty of the court to determine whether passage of such ordinance is an arbitrary, unreasonable, and capricious exercise of the police power. All of these case opinions focus on the arbitrary and capricious nature of the decisions being made by the Planning Commission and the approving body. It's important to use this as a litmus test as you all go through the process of making decisions. I would like to take a few minutes to discuss unconstitutional takings. This is not an issue that's addressed frequently by Oklahoma courts, but it's very important. The U.S. Constitution prohibits the government from taking private land for public use without providing just compensation to the landowner. A government taking is generally thought of as a physical taking of a landowner's property. However, if a regulation goes too far, it will be recognized as a taking. Regulatory takings were first recognized by the U.S. Supreme Court in 1922. A regulatory taking occurs when a governmental regulation limits the use of private property to such a degree that it effectively deprives the property of any value. The U.S. Supreme Court has recognized regulatory takings in two situations. First, when a regulation leaves the landowner with no economically viable use of the land, known as a categorical taking, and two, based upon the balancing test established in Penn Central Transportation Company versus the City of New York City. A categorical taking occurs when a regulation denies all economically beneficial or productive use of land. For example, in the case of Lucas versus South Carolina Coastal Council, the United States Supreme Court held that a law prohibiting the owner of beachfront property from erecting any permanent structures rendered the property valueless, which therefore resulted in an unconstitutional taking. If the regulation does not deprive the property of all economic value, courts will analyze the regulation under the Penn Central balancing test. The Penn Central case involved a challenge to New York City's landmark preservation law, which prevented the Penn Central Transportation Company from constructing a skyscraper on top of Grand Central Station. This is a photograph of Grand Central Station. Basically, what the developers wanted to do was build a skyscraper over this area, and that request was denied by the City of New York. The United States Supreme Court held that application of the law did not constitute a taking based on a three-part balancing test, which requires courts to consider 1. The character of the state action, 2. The economic impact of the regulation, and 3. The extent to which the regulation has interfered with a distinct investment-based expectation. I would like to take just a moment to tell you that these are very complicated issues. Your municipal attorney should have the ability to give you guidance on this. However, it's important for you to realize that when you are making determinations about private property, you need to consider whether implementation of the regulation will basically constitute a taking. I want to take just a few minutes and talk to you about the ideal council member. The ideal city council member does not take things personally and recognizes that sometimes reasonable minds may differ, is respectful of fellow commission members, staff, and the public, listens to and respects all points of view, does not criticize staff in public, retains an open mind, advises the city attorney of potential conflicts, is able to decide difficult issues with integrity, considering the best interests of the city, understands the role of the Planning Commission, the City Council, staff, and the city manager, does not act arbitrarily or beyond the appropriate legal process, and recognizes the complexity of running a city. Next, I would like to talk to you about a case that I handled on behalf of the city of Broken Arrow. This is a really good example of some of the things that you need to think about as you advance through consideration of various items. This was a case entitled U.S. Cellular Telephone of Greater Tulsa versus the City of Broken Arrow. This was a case that was argued before the 10th Circuit Court of Appeals in 2003. This is an image of cell towers. Now, as we all know, the technology has advanced considerably since 2003. However, back at that time, this ended up being the landmark case that decided cell tower placement for all of the states that are located within the 10th Circuit Court of Appeals. This particular case involved two separate suits filed in federal district court challenging decisions by the City of Broken Arrow denying specific use permits for the construction of cellular transmission towers. At the district court level, the city won one and lost the other. The first thing that I want to talk to you about is the regulations that were set forth in the Broken Arrow Code of Ordinances. The code noted that as part of the permitting process and in determining whether or not to grant the permit, the council shall consider the height of the tower, the proximity of the tower to residential structures, the nature of uses on adjacent and nearby properties, the surrounding topography, the surrounding tree coverage, the design of the tower, proposed ingress and egress, whether co-location is possible, and the suitability of nearby towers. There are a few points that I would like to make about this particular case as well. First, as I previously mentioned, this was going to be the landmark cell tower placement case for all of the states located within the 10th Circuit's jurisdiction. Second, the case was accepted for oral argument. Third, the record prepared by the city planner in this particular case was outstanding and likely won the case for the city. Fourth, one of the council members stated on the record, the town is starting to look like a porcupine. I'd like to talk about that comment for just a moment. I thought that was quite entertaining. The 10th Circuit, not so much. It's just a really good reminder that when you're talking on the record to be thoughtful about what you're saying. This is Farhad Daroga. Farhad Daroga is, I think, the godfather, as it were, of planning and zoning in the state of Oklahoma. Mr. Daroga has been with the city of Broken Arrow for probably 40 years. Mr. Daroga was instrumental in achieving success for the city of Broken Arrow on these issues. In this case, the court noted that in Mr. Daroga's closing remarks, he stated, staff recommends that the application be denied due to improper zoning, the zoning ordinance discouraging towers in the A1 district, the height of the tower adjacent to a single-family residential neighborhood, and the surrounding residential uses. Mr. Daroga did a wonderful job summarizing this for consideration by the court. Although he was not an elected official, his brief summary really serves as a guideline or a guidepost for planning commission members when they vote against a specific rezoning or planning request. Things additionally working in the city's favor were the number of articulate protestants, the backup materials that were provided in the packet for the council and the planning commission's consideration, the comments of the council members supporting the denial, well-written codes and zoning regulations, substantial compliance with the Telecommunications Act, and utilization of the degrees of work. One thing that I always tell people when I give advice is the degrees of work. We have a saying, this much work saves this much work. In this particular case, planning staff did this much work at the beginning, and it ended up saving this much work. So if you do your homework ahead of time and you read the packets contain this information, it really sets you up for success if an issue is challenged to the court. I'm going to take a few minutes to highlight what I consider to be best practices for planning commissioners. This is based upon my experience in providing advice to planning commissions and city council members. First, review the packages prepared by staff. 2, recognize that citizens have the right to develop their property in accordance with the comprehensive plan and the planning and zoning ordinances. Number 3, don't speculate as to the viability of other uses. 4, understand that if you recommend denial, you must give reasons why. Number 5, understand that there are other processes in place to address property limitations, such as setbacks, distances, permits, and specific use permits. Number 6, don't convolute the record. In other words, don't spend a considerable amount of time talking about things that really aren't material to the decision that you're being asked to make. Number 7, respect the process. Number 8, I encourage you not to attend council meetings or do independent investigations. It's critically important that you work through staff and that you allow the process to work through. After you make a decision as a planning commission, your findings will be forwarded to the city council. Don't appear at the city council meeting and advocate one way or the other. Number 9, appreciate that infrastructure is generally a function of the platting process. And 10, treat everyone that appears with respect. Number 11, make use of the table. If you're unsure about something, feel free to always move to table it, always to a date certain so as not to lose the notification. Number 12, take advantage of educational opportunities. There are lots of those out there. Read articles, watch the actions of other planning commissions, but always take advantage of any opportunity that you have to further your understanding of the planning and zoning process. Number 13, bad facts make bad law. So be sure and consider that. If the facts aren't palatable to you or to the community, you need to take that into account when you make a decision. Number 14, appreciate that sometimes less is more. That goes back to the point that I made about convoluting the record and deviating from the matter at hand. And number 15, motions matter. Now, by that, I mean it is very, very important for you all to be clear in the motion that you're planning to make or that you want to make. If your decision is based upon things like items contained in the staff report or the comments of those that appear at the Planning Commission, be sure and make sure that that's part of the motion. Thank you for giving me the opportunity to provide this information. As always, if you have any questions, don't hesitate to call. Thank you.